Hello and welcome to the Herrington Carmichael Employment Law Update for June 2017. I'm Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I'm bringing you a video update on the latest developments in employment law. This month has been quite a quiet month, so rather than the usual 4 topics, I've only got 3 for you. Let's start with the big thing on the horizon, the general election. Today, as I'm recording this, is the 7th of June, and tomorrow there's a general election. There are various political parties putting out their proposals in relation to various matters, including employment law. Now, there are many political parties available, as I'm sure you are well aware, but the Conservative Party and the Labour Party have put forward various different views in relation to what should or should not take place. These views are going to fundamentally change the landscape of employment law in the UK as we move forward over the next few years. So it's a time to be watching, it's a time to be reading, and a time to be checking what's coming. And as always, we'll be bringing you the latest developments as and when they arise. Moving on to cases, let's start with the first case, which is the Government Legal Services and Brooks. This case relates to a disability discrimination claim for a failure to make reasonable adjustments that was brought by a lady with Asperger's syndrome when she was placed through a psychometric test as part of a recruitment process. She specifically asked for reasonable adjustments to be made, and they were not accommodated in the recruitment process. The Government Legal Service were criticised, the disability discrimination claim succeeded, and this is a really good example for employers where they are dealing with individuals with complex mental health difficulties. They do have to look very carefully at recruitment processes and make reasonable adjustments. I would even say you have to look at it at the point you're aware of the mental health issue and make sure that the recruitment process appropriately accommodates that individual. Please do look carefully, please do take your time, please do consider it, because you can be on the end of some quite chunky claims. Next, the case of Beat and Croydon Health Service, which relates to the issue of whistleblowing. In this case, there was an unusual set of circumstances relating to an operation, a dismissal and a whistleblow, which took place all in a very short space of time. The hospital, as part of subsequent disciplinary proceedings, disregarded a whistleblower, saying it wasn't a genuine protective disclosure. However, the individual concerned continued to appeal the claim, and it was found at both the tribunal and subsequently the Court of Appeal that genuine whistleblowers had been made, and effectively the sole reason for the dismissal was the whistleblower. What is this for employers? Really, what you've got to be careful of here is where employees are raising legitimate complaints, that you are very clear as to what the reason for the dismissal is, and you don't simply disregard a complaint that is raised, whether you think it is genuinely falling within a whistleblower or protected disclosure framework. Be careful, look at what employees say to you, make sure you deal with it and don't disregard it. That's it from me this month. I hope you have a very good month, and I'll be back in July. Thank you.